My name is Carlos Delgado, and I'll be briefing Joy Salmon versus Virginia Atkinson, 137 SW3D 383, Supreme Court of Arkansas, December 11th, 2003. First of all, relevant facts. The substantive facts are the case in question revolves around another case in which the appellant, Joy Salmon, hired the appellee's Atkinson law offices to pursue a claim in damages against the estate of George Brown. The appellee's contract was on a contingency basis, and in June 2000 stated that it is understood in the event of no recovery, no fee shall be charged to Atkinson law offices. After 48 hours in total of questioning witnesses and researching the appellant's claim, Atkinson law offices provided a petition requiring the appellant's signature. Salmon communicated she would think about it, then later sent the appellees a notice that their services were no longer required. The appellee subsequently sent a letter seeking $7,200 in quantum merit for their services, according to the regular $150 per hour rate. On May 10, 2001, the appellees then filed a suit against the appellant in circuit court, seeking the aforementioned money because of their services prior to being discharged before trial. The procedural facts are that the circuit court ruled in favor of the appellees. The appellant then filed a motion for judgment notwithstanding the verdict. Using the specificity of the contingent contract, they filed stating that there was no recovery of her claim on Brown's estate at the time of the dismissal of the appellees. Therefore, no fee should be charged, and the verdict of the court was not based on substantial evidence. The trial court denied this motion, and another motion of the same kind filed after by the appellant. Then the appellant filed a motion of appeal with the reasoning that the contract states that no fee shall be charged in the event of no recovery, and she had not received this recovery. Therefore, it was an error to rule in favor of the appellees and reward any fees. The appellant also stated that it impaired her right as a client to discharge the appellees. The applicable laws questioned are the rules. First of all, the California rule, which does not award quantum merit to the discharge attorney if the client does not receive the desired verdict. And the New York rule that awards quantum merit to the discharge attorney no matter what the contract both parties agreed upon states. The remedies sought by both parties are by the appellant that no fee will be rewarded to Atkinson law offices, and the appellee that $7,200 be awarded in quantum merit for the services provided by the law office prior to their discharge. The issue is that in the case questioning whether to give quantum merit after a discharge with a client binded by a contingent contract making payment dependent on a certain outcome of the court should rule in favor of the New York rule, since when the client dismisses the attorney, any contract had before is terminated as well, making the conditionality of the payment invalid. The holding says yes, and the reasoning is that the New York Court of Appeals said that the value of an attorney is not measured by the indesirable result of the client, but is based on their character, education, and behavior, and the services have been provided and either way, and it is fair that the attorney be rewarded according to his or her work. Another reasoning is that the client would be unfairly enriched if they would not have to pay for the services of an attorney. Therefore, quantum merit is implied in the contract. And third, the right as a client to dismiss an attorney would not be violated at all because it would not be compromised by allowing the attorney to claim fees according to their services afterwards. And the rule of law is that the verdict of this case establishes the favor of the New York rule over the California rule and could make future juries favor the New York rule because of this.